very much. I think the way we reorganized the session was very good because Tom's presentation leads very nicely into mine because he mentioned litigation, and I want to talk about litigating for children's rights in the criminal justice system by giving just 3 South African case examples. Next slide, please. No, go back one, please. Why have I put a picture of a starfish there? Well, I'm sure you've all heard the story of the starfish, but let me just remind you, man standing on the beach, many starfish washing up and getting stranded on the sand. And the man is picking them up one by one, throwing them back into the sea. Another person walks past and says, "What are you doing?" He says, "I'm saving the starfish." And he says, "But look, there's starfish all the way that way, all the way that way. There must be hundreds of thousands of starfish on this beach. You really can't make a difference doing this." The man bends down, picks up one more starfish, throws it back, and it made a difference to that one. And so when lawyers go to court every day and represent individual children, that's what they're doing. They're saving those starfish, and they are, at least if they can't entirely save them, they're ameliorating their conditions. They're ensuring that they're doing the best that they can for the starfish. But starfish will still keep washing up. And so the question is, what could we do to sort of build sandbanks to lessen the number of the starfish that wash up? And this is where I think litigation can make a difference if it is strategic and it is done in an impactful way so that we can capture and assist more than one child at a time. And Tom's already shown us there the American examples, the great examples of Roper versus Simmons, Miller versus Alabama. And I think I thought it would be interesting to show that even in developing countries we can do this too. One does have to have certain ingredients. An independent judiciary is important, and the rule of law is rather indispensable. But I think that many countries do have the conditions where they could, if they have the stare decisis, there are many countries in Africa, for example, that could be doing this litigation. Some are doing it, but I think that we could all do more. And so legal aid lawyers very often are sitting on a ton of possible strategic litigation cases, but because they're very busy throwing back starfish, they sometimes don't see them. So it often needs an interaction between organizations that have a little bit more time to carefully prepare cases, and more dialogue going on about why do we keep seeing this problem coming up again and again? Can't we do something bigger about it? So the next slide is a case called Centre for Child Law versus the Ministry of Justice, and you'll see there was an amicus curiae in this case as well. And this case was about minimum sentences for child offenders. Now in South Africa we are proud of the fact that we have an excellent constitution which contains a children's rights provision, and also we generally have quite protective and good laws for children. But even our new government has drafted some laws that have had very negative and unfortunate consequences for children. One of those was the law relating to minimum sentences, which, you know what minimum sentences are, I won't bother to explain that, but what was relevant about this was that it included 16 and 17-year-olds within its ambit, and it included life imprisonment, mandatory, or sorry, not really mandatory, but automatic life imprisonment in certain circumstances, although the court could depart if they found substantial and compelling reasons. The Centre for Child Law took this matter up, and we didn't even identify an individual clients because the law had just come into operation. We didn't want to wait. And South Africa has very relaxed standing rules, and so we were able to actually argue that it was inevitable children would be sentenced under the law, and the Constitutional Court upheld that and said yes, it would have been an exercise in needless legal formalism, said Justice Edwin Cameron, for us to wait until somebody was actually sentenced. So we brought the case, and we argued that under our constitution, detention of children is a measure of last resort and must be for the shortest appropriate period of time. Minimum sentences turns that on its head. First resort and longest possible period of time. And we won, and the law was struck down as unconstitutional vis-a-vis 16 and 17-year-olds. Next slide, please. The next case I want to tell you about is to do with the Sexual Offences Act. Now, you may have experienced this in your country as well, but very often when the legislature wants to show how tough they are on something like sexual offences, they tend to lose the plot somewhere along the line and forget that child offenders are also going to get caught up in these very harsh new laws that they're introducing. And that's exactly what happened here, where the new Sexual Offences Act criminalised for the first time consensual sexual activity between children. So in other words, we always had a law that said if one person was over 16, they couldn't have sex with a child that was under 16. But in this case, we're talking about where they're both under 16. And now they would both be prosecuted in those circumstances. And there was quite a lot of outcry because it was also very broad. It wasn't just sexual intercourse, it was all kinds of sexual interaction. You could even include kissing if you read it broadly enough. And just the next slide will show you what the public thought about this. The media did think it was a ridiculous law. Mr. Similani was our Director of Public Prosecutions, our National Director at the time. Here he is rushing off to prosecute a real case, rape charge against a girl who was 15 for consensual sexual activity, and his assistant is running behind with a brain on his hand saying, "Sir, I think you might be needing this." Again, this case was won. It's a very nice judgment, and I urge you all to read it. You can find it on the Constitutional Court website. It confirmed that children do have rights to privacy and dignity. They are allowed to experiment with age-appropriate sexual interest in one another if it is consensual. The third case is Jay versus National Director of Public Prosecutions. And this case is about the automatic placement of child sex offenders on the sex offenders register. Our new Sexual Offences Act introduced provisions which say that if you are convicted of a sexual offence, there is no opportunity to argue why you should not be placed on the sex offenders register. You just go on. And it's not difficult to be placed on the sex offenders register for life if you have more than one conviction, or if you are sentenced to more than 18 months imprisonment, even if it's wholly suspended. So it's just very easy to get on the sex offenders register. Jay was a 15-year-old boy who had committed a sexual offence, and his case went on automatic review. And it was, in fact, the judge, the reviewing judge, that said, this doesn't seem right. There's something wrong with this law here. Jay was represented by Legal Aid South Africa, who represented him ably all the way up to the Constitutional Court. The Centre for Child Law was invited in by the court as an amicus curiae. We then also, after the High Court hearing, we held a workshop with all the children's rights NGOs because we wanted to know how the NGOs who deal with child victims felt about this as well, because obviously some are very interested in child offenders, but as a children's rights organisation, we are interested in all children, so we wanted this is one of those tricky situations where we're dealing with both. But all the organisations agreed that it was not appropriate to automatically place child sex offenders on the register, that we should at least be assessing them, and we should probably have a presumption that they do not go on the register unless there are compelling reasons why they should go on. So this case ended up in the Constitutional Court. Again, it was won, and the law was found to be unconstitutional vis-a-vis child offenders, and the finding was suspended pending Parliament correcting that law. So I just thought I would bring to you these examples, and if you're interested in looking at any of them, they're on both the Centre for Child Law's website or on the Constitutional Court's website, and happy reading.